sige. One estate planning device that is commonly used worldwide is the last will and testament. So this is easy to do, especially among lawyers, right?
Yes,
and as I usually explain, that we have two kinds of last will and testament: the holographic and the notarized. The notarized will. So the holographic is anyone actually can do that as long as entirely written, dated, and signed by the testator. So meaning you write everything in your own handwriting, entirely written, dated, and signed. But you need to know the substantive provisions of the succession laws.
Okay.
So sometimes there are complications when you are to disinherit somebody. So you have to follow the succession law. So you have to learn about the grounds for disinheritance and who are the compulsory heirs. So because it might be possible that when you do your estate plan through the last will and testament, you might be unintentionally disinheriting somebody else, giving this to one of your children, thinking that by doing so is actually making your will valid. So it could be invalidated. So meaning in a lawyer's lingo, we call that preterition because somebody has been omitted. So doing last will and testament is actually holographic, is easy for layman, but the notarial last will and testament, you should hire a lawyer to do that. You should hire a lawyer to do that because there are technical requirements, like the signing on the left page, the attestation clause, or else it will be invalidated.
Yes, okay.
So that's one. So, but last will and testament, as I said earlier, has to be probated, and a probate cost, right, is expensive, ranging from 3 to 10%. Let us say the spouses chose the last will and testament as a mode of estate planning, and the husband died first, right? Normally, yung lalaki naman na nauna, then of course the wife gets to inherit the share of the husband, right? And then the wife dies later. You know, you see, we are talking about two probate here. So probate first on the properties of the the husband, will go to the wife and the children, and then when the wife dies, it has to be probated again. So double probate cost. So there are estate planning devices which we call superstar of estate planning, which actually can meet the three objectives of estate planning: parties' intent, avoidance of probate, and avoidance of or reduction of estate tax. And one of which is of course where you are connected, insurance, right? Let us say that the designated beneficiary is one of your children, right? And then that goes to your child whether you have other children or not, right? And then of course your party's intent is followed because you want the proceeds of this insurance to go to your particular child. It avoids probate. The insurance company will just release the money to the designated heir upon compliance with certain requirements, and it avoids estate tax if the designation is irrevocable, right? So it is exempt actually from estate tax, and it's not also subject to income tax. So there is no tax. So now you can say that insurance is a superstar of estate planning. But there are things that insurance cannot do. And of course, trust is another superstar of estate planning. Actually, this is commonly used in the United States, right? They have what they call the revocable living trust and the irrevocable trust, right? These are two kinds of trust commonly used. But in the Philippines, it is seldom used.
Okay. Bakit hindi ginagamit to sa Pinas commonly?
Because they thought that it's not applicable. But we have laws, provisions in the civil code, although we have only 18 provisions in the civil code about trust. But a lot of, trust experts would say that the 18 provisions in the civil code are in fact good because it gives flexibility to the estate planner.
Okay.
So you can actually practically choose how to design your estate plan. It's not limited. Unlike in the US, there is a restatement on the law of trust. They have more than 400 provisions. So each scenario is considered. In the Philippines, we have so much flexibility. So why is trust considered the superstar of estate planning? Right? That's another question.
Yes, that's correct.
Right. Let us say that you want to transfer your property to an adult child of yours.
Okay.
So what instrument will you use? Diba? Deed of absolute sale.
Yes,
Maybe, right?
Yes.
That's commonly used by Filipinos. Diba? Yung sabi nila, the DOAS or the DAS, the Deed of Absolute Sale. So I transfer nila to outright and they tell you upon consultation with others, capital gains tax lang yan, 6% ang bayad. At saka DST na 1.5%. Mura lang. Diba? Yung lilipat. So, when you transfer that to your adult child through the use of Deed of Absolute Sale, do you notice that the child is able to accept the property because he is of legal age, right? So you do that through a deed of absolute sale. Supposing you want to give properties to your minor children para hindi naman agrabyado yung minor, na bigyan mo yung adult, you have to give to minor children. Of course, you cannot do that through a deed of absolute sale because they're minor. The transferee of the property or the buyer must have actually legal capacity, must be of legal capacity, of legal age, right? So 18 and above, right, to accept the property as a transferee of the property. But through a deed of donation, you can actually transfer it to the minor children as long as the transferee has a juridical personality. So, as long as the transfer is a person, so even an unborn child can be a subject of, or a donation, as long as he be born alive. Yeah. So, may condition niya na ganyan. So, you can do that through a deed of donation. So, ita-transfer mo, di ba, through a deed of donation sa anak mo. But, what if you do estate planning? Planning not for this generation alone and planning for many generations.
For 5 generations.
Let's say just 2 generations.
Okay.
So most of us do not plan our estate more than 1 generation. Most of us just 1 generation. Lipat lang na ganito, right? Even nga, actually, the truth is, most of us have no plans at all, right? Right? Yes. But those who plan, they plan only for 1 generation. Let us say you have a good foresight and you want to plan for 2 generations. Anong asset planning device ang gagamitin mo? Ano naisip mo?
That's exactly really good question.
Trust ang gagamitin mo. Trust. Kaya siya tinatawag na trust is a superstar of estate planning.
Yeah. And I think you got plenty of trust. Okay? Plenty of trust.
Kasi ang trust generally can cover future children.
Yeah.
You see, deed of sale cannot cover future children. Deed of donation cannot cover. But trust can cover future children.
Wow.
That's generally the nature of this trust. It's a superstar.
Okay, attorney, I just thought about it. What if meron akong 18 years old na may mental retardation? Can I still use trust?
Yes. Yan nga, ang trust is very effective instrument for that kind of scenario.
Yeah.
Or, kaya yung mga special child, kaya nga siya tinawag na special, diba? Kasi lagi silang child. Lagi silang mabait.
That's correct.
Right? And you have to protect them.
Yes.
So, pag namatay ka without doing anything, paano na lang special child mo? He's susceptible to abuse. So you have to ensure that, di ba, he lives fully and fully protected. So how do you do that? So kailangan mo na somebody. So kaya nga, somebody to manage yung properties or money niya and somebody to take care of his person. So it's going to do that. So you actually, ang mga bangko ngayon, they accept, you know, yung mga trust, revocable or irrevocable, but they can only accept so far as yung mga properties.
Okay.
Pero in so far as yung, you know, yung taking care of the person, that is outside their competence and jurisdiction. In fact, the law does not allow them to do that. So you have to have two trustees. Well, insofar as the one managing the money or the property, you need, for example, a bank as a trustee, a reputable one, or you need a person, probably your aunt or your cousin, to be a trustee to make sure that this person, the special child, is amply protected.
Okay.
So it is contained in the instrument of trust.
Right.
So how it will work.
Yes.
And the nature of the trust is usually private and confidential. And that is another thing that is good.
So you cannot disclose this one directly?
Yes, you cannot disclose because it is confidential, right? So like that, the terms of the trust cannot be actually open to the public, so public cannot simply scrutinize that.
Even if they're public figure, let's say for example.
Yes. But there are certain, the public figure is meaning if you're connected with the government, that's another issue.
Okay.
Hindi naman yan ang topic natin, right? Di ba?
Okay.
Like yung SALN, declaration, so hindi naman yon. But we're talking generally about di ba, private people, right? Planning yung kanilang estate.
Yes, yes.
So kasi sometimes you don't want your properties open to the public, right? So if you prepare or your estate planning device is last will and testament, then when you die, you can simply Google your name like Michael Jackson or Elvis Presley, and your last will and testament will appear, just like Whitney Houston.
Yes.
But try to Google the estate plan of Steve Jobs, you cannot find it because he used trust. Yeah.
Amazing.
So you see, that's one thing. But the sophistication lies in the combination. So meaning, if you prepare last will and testament alone, well, you're just that is just very simple one, right? And or if you do trust, that's a simple one also, or insurance, a simple one. But if you combine them in just one document,
really different.
There lies the sophistication.
Okay.
So, for example, you chose last will and testament. You have a lot of properties. You have investments. You have companies, corporations, and then you want to make sure that the corporations will last for many generations. You do also succession planning, but you want also to leave a legacy. So you create a foundation, right? So you prepare a last will and testament. In the last will and testament, there is a testamentary trust.
Okay.
So meaning there's a trustee involved in managing or running your properties, and then there is a foundation that you created.
Wow.
So and if you donate properties to the foundation, it will be donors tax exempt because it's a non-stock, non-profit institution, and the donation can be in the form of insurance. You buy insurance. So you just pay the premium. When you die, the proceeds will go to the foundation. You see? So I use last will and testament, I use donation, I use foundation, I use insurance, and I use trust.
Wow, 5.
5. In one document.
I think on your book, you cited at least 10 or 12.
It could be more.
Yeah, it could be more.
Yeah, there are a lot of estate planning devices. Abot yan ng mga 40. Ano yan? Mga specific na yung iba.
Attorney, you mentioned on your book, regardless of age or income, everyone should have an estate plan. Can you expound on it?
Yes, kasi ang misconception ng tao is that you need estate planning only when you are old and dying. Hindi ba common sense lang yan? That when you are old and dying, di ba? Tapos ngayon kailangan mo talagang mag-isip paano mo i-dispose yung property. But the fact is, or if you do that during the time that you are dying, right? As meron din tax consequence yan in the past. Pero ngayon medyo nawala na yan because of the amendments in the di ba? In the estate tax law.
Yes.
Kasi before that will be construed as transfer and contemplation of debt. So you transfer it, na thought of, because of the impending debt, right? So ang tax dyan before, that's before December 31, 2017, was 20%, right? In excess of 10 million. Compared mo, pag tina-transfer mo like a deed of absolute sale, right? Ang deed of absolute sale is 6% lang yan kung capital asset. Control deed of donation graduated, diba, from 0% to a maximum of 15%, which is lower kung tina-transfer mo during lifetime. So, kaya nga kung gagawin mo lang yan pag mamatay ka na, maaring too late na, right? So, kasi ang una-una is, di ba, alam naman natin, pag nagmamadali ka i-transfer, something is maring, di ba, mamali along the way. Oo. So, ang planning is, of course, as early as possible. Ang planning mo naman should be flexible. So, yes. Hindi yung, ito na yon naibigay mo na, right? Hindi mo na mababawi. Kaya meron tayong tinatawag ng instrument. Kaya sabi ko sa iyo, depende sa party's intent. For example, if you want to enjoy yung property mo sa Ayala, Alabang, you're staying there. Pag nilipat mo yan sa anak mo, right, kaagad, through a deed of absolute sale, wala ka ng control. But if you do some sort of estate planning, like nilipat mo lamang yung naked ownership, pero yung usufruct is retained sa'yo, di ba, yung use until you die, then you're doing estate planning. Ay hindi mo alam, di ba, kung ano yung use na yun, yung usufruct can also be actually transferred, pero can be merged doon sa who is the owner of the naked title eventually. Yes, you're planning it ahead. So let us say, I'll give you another example. 5 children, ng mag-asawa, husband and wife, buhay pa sila pareho. And let's say they're only 40 years old. Ang sabihin nyo, hindi ka mag-estate plan kasi bata pa. Diba? That is again a misconception. Dapat mag-estate plan ka na. Kung ang anak mo 1, palagi mo sunod-sunod 1, 2, 3, 4, 5, right? May properties kasi Isabela na 5 hectares. So i-partition mo. Tigo 1 hectare sila. Right? So i-transfer mo yan isa-isa sa kanila. Magkano ang value ng property sa Isabela? Agricultural land, let's say, rice land. Wala pa siguro 500,000 yan per hectare, di ba? Kahit na class A yon, right? Under sa new estate tax law, ang first 250,000 sa donation is exempt. So each spouse is considered a separate taxable personality or entity. So each one of them can claim yung 250,000 exemptions. So ngayon, nakuha mo yon. So let us say mag-umpisa ka doon sa pinaka bata, magdo-donate ka ng year 2019 na 1 hectare sa anak mo, youngest. 2020, another child. Until 5th year, na-donate mo yung 5 hektarya to your 5 children, totally tax-free. You're doing estate planning, di ba? Reduction or avoidance of taxes. That's one. And avoidance of probate. Nasa pangalan na nila. So pag namatay ka, hindi na yan dadaan. Anong cost of hiring a lawyer to transfer the property? Right? That's very big. Marami pang lawyers niloloko. 'Di ba? Yung kanilang mga yung kanilang mga clients.
Yes, that's correct.
And just yesterday I received a text. Sabi niya, Attorney Ed, how much do you charge for extrajudicial settlement? Sa Cebu Integrated Bar Guidelines daw, they charge 1% ng value ng estate. Sabi ko, that is too much. O, kita mo yun. If yung 100 million na estate na yan, namatay ka without doing anything, i-charge ka lang ng lawyer just doing the extrajudicial settlement of estate, 1%. That's 1 million pesos na. Wala ka nga kasi pambayad eh. Saan mo kukunin yun? You have to sell properties. Kaso, hindi nila naisip yon because a lot of people never thought of dying. Diba? They think they will live forever. So, kaya nga, regardless of your age, you should do as early as possible. Kaya when you go on with your life, titingnan mo, when you buy something like this, kanino ba ibibigay ito? And when is the appropriate time giving this? talking about anything, even properties or legacy, real estate, cars, or jewelries, di ba? Sabi mo, nag-iipon ka ng isang set ng diamonds para ibigay mo sa daughter mo, etc. Agagawa ka lahat na yan. Nagpaplano ka. You need to leave something. Instructions. So, in what form? Yun lang ang question doon.
So, hindi ito nakikita ng mga majority ng mga Filipino right now. That's the reason why they don't do it at all?
Ano, kasi siguro lack of understanding. And second is nature yan eh. Na, yun nga, ang nature ng tao, not only the Filipino, is that they do not think of anything that is not immediately needed. Okay. Diba? Yung urgent lang ang pinopokus nila. Like yung food for the day, right? Okay, may kailangan nilang bumili ng sasakyan. That's something like. Pero there are only very few people, diba? Who have foresight about yung kanilang future generations.
Yeah.
So they do, di ba, sort of succession planning and estate planning. So ang naman nila is it all redounds sa values kasi ng tao eh. So kung ang values mo na wala, pag namataya ka, bahala na sila mag-away-away, bahala na sila, patay na ako eh. Right? Pero ang value mo is like you want to keep your family together and the loved ones especially. At yung values that you actually, diba, treasured the most, you're making sure that it is passed on to the next generation, sort of legacy. Then estate planning is actually very important to you. So it's not about money alone.
That's correct.
It's about transference of your sacred and treasured values.
Okay. Last two questions, attorney. You've been servicing different clients, which is high net worth, elite in the society, and celebrities. What did you notice by simply servicing them? Yung mga, the way how they think about estate planning right now?
Iba-iba naman. So, a lot of my clients are just focused on, getting more money, like, because that's just natural. So they have this investment, and so or they have this business, and they want to earn more profit, and that is just natural, right?
Yes, that's right.
But well, some of my clients, high net worths, have actually a better outlook, not only in life, but about the future of their family, because of their past experiences also with their own family. So meaning their parents, grandparents, that resulted into some or certain disputes. So they want to avoid that. They don't want to repeat the same mistake. So when I actually introduced myself to one of my clients, I was engaged as in this estate planning thing, and then he was actually very happy that I was actually considering the transfer of property for many generations. A lot of lawyers he talked to was actually a lot of lawyers. He talked to dealt only with existing relationship, existing properties, and did not touch about future generations. So transfer property to his children and to his children's children.
Wow.
So you have to consider that, and the possibility of changes in taxation. You have also to consider that, and maybe citizenship, or one of the children gets married to another, right? And you have to consider whether entering into a prenuptial agreement, or if the prospective spouse does not want to enter into prenuptial agreement, what is the alternative?
Okay.
So there are so many considerations.
I do have a client who's currently asking if she will be signing a prenuptial agreement because she will be marrying someone who got big businesses. Yung future husband will have a big business. So, can you give us quick tips what's the purpose of the prenuptial agreement?
The prenuptial agreement is valid only during lifetime. The woman and the man would enter into prenuptial. Let's say the prenuptial arrangement agreed upon is complete separation of property. So meaning kanya-kanya sila, but they will contribute to common expense ng kanilang regime of partnership. So when you acquire property, pera mo yon. When you dispose, you don't need to get the consent of the other spouse. So that's a complete separation. But most often in a Philippine setting is that when you ask, for example, the girl who is not rich to sign a prenuptial agreement, ma-open yun pati yung family niya. Sabi niya, kung wala naman tiwala sa iyo sa umpisa pa lang, di ba? Wala din tiwala yan pagkasal na kayo. So wag mo nala ituloy. So kung ikaw, for example, hindi ka sigurado dun sa mapapangasawa na anak mo, and of course, and asking them to sign a prenuptial agreement might result into, cancellation of wedding, right? So what do you do? Kaya sinabi ko sa iyo kanina, trust is the superstar. Trust can do many things. Ang last will and testament can only do one thing, transfer property at death. But ang trust has so many diversified purpose. Sabi, special child, transfer property at death. Pwede siya maging prenuptial trust o marital trust. So, for example, di ba, itong parents ng lalaki, right, instead of, transferring the property sa kanyang anak na lalaki, kasi pag transfer niya ngayon at anak niya lalaki gets married to this woman, magiging 50-50 owner na silang dalawa under absolute community of partnership. Diba? That's in the family code. So ang gagawin mo, instead of transferring the property to your son before marriage, ang ginagawa ng iba, ita-transfer yung property after marriage, pero through a deed of donation. Ilalagay lang kay son married to the woman, hindi to son and woman. Para sa son lang. Pero sabi ko nga sa iyo, ang prenuptial is valid only during lifetime. If the son dies, the woman inherits. And the woman marries again. Right? So there's a possibility that the property of the parents would go to a stranger. So mawala sa bloodline. So anong gagawin mo ngayon to ensure that it goes along the bloodline? It's through the use of trust. So for example dito, si parents will create a trust open sa isang credible bank as trustee. Nilagay niya doon like David Family Trust, right? Trustee is yung bank X, right? Ngayon, if David dies, right, katok tayo, then the property will go to your, actually, the child of David. Kasi ikaw yung anak, ha? Assume natin, ikaw yung anak. Okay, pinamanahan ka ng parents mo. So bago ka mag-asawa. Pero may condition ng parents mo that pag namatay ka, right, mapupunta yan sa anak mo. Hindi doon sa asawa mo. Or mapupunta doon sa anak na anak mo. So along the bloodline.
Still with the bloodline.
Oo.
He's a stranger.
Yes. Pero yung wordings ng trust, sensitive yan. So you make sure that it follows the law.
That's correct. Okay.
Kaya sensitive. Kaya you need a very good lawyer to actually to drop the document.
Okay. Yeah.